Hello everyone, Derek with Tatango.com. I'm here with TCPA attorney Ernesto Mendieta, and we're talking about TCPA cases. So these are cases that are brought against brands for TCPA violations. So luckily I have a TCPA attorney to explain some of these cases to us. So the case we're going to be discussing today is Fisher versus Alarm.com. And if you're not familiar with lawsuits, Fisher is the person, so that's the consumer, they come first, versus Alarm.com, that's the brand.
Correct. Alarm.com is a brand that sells home security products.
So what happened here? And this one is interesting because we mainly cover text messaging, but this one is calls.
Yes.
Okay, but then can you explain why also this even matters to text messengers?
Correct. This is about calls, this specific case, but I'm going to talk about vicarious liability, and we can say what's that implication to text messaging.
Okay.
Right? So the facts here are very simple. Nick Fisher, this person, sued Alarm.com and another company saying, I have received this many unsolicited calls, some even with pre-recorded messages, selling me security products, some of them by Alarm.com. Right? So he goes to court, presents a claim, and a lawsuit against Alarm.com for all the calls, saying, well, I had this many calls, then, with the damages by the TCPA, that it's $500 per call or $1,500 per each knowingly made call, then he went for that. Here, the judge dismissed his claim. Why? The first part of his claim was a technical violation that is very specific. We don't need to talk about it. But the second one, the judge said there's no reasonable inference to say that Alarm.com has vicarious liability for the calls you received. Let's explain this, right? So first, for a TCPA lawsuit to proceed, you have to say, I'm suing Alarm.com because they call me, right? They have to have some kind of liability.
Yep.
Under the TCPA, there's this thing, recognizes this general principle of law called vicarious liability. It means that the agents, when they are acting on behalf of their principal, then the principal is responsible. A clear example of this is if a FedEx driver crashes its car in the street, then you're gonna sue FedEx, right? Because you can sue the driver too, but you can also sue FedEx because FedEx is the principal and the driver is the agent.
Because there's a relationship there.
Yeah, there's a relationship. It's an employee. He's acting on behalf of FedEx. So if you go to court, you can sue the principal, which is the company behind the person.
And this, I think, applies to text message marketing because a lot of brands will hire a marketing agency to run their SMS campaign for them. In that kind of context where they've actually hired an agency and there's a relationship and the brand has said, agency, you power our SMS and here's the contract and they're all coordinating on it, the brand would be sued, for the agency's work.
Yeah, so we always say hiring a contractor or hiring a software provider does not get you out or does not release you of liability, right?
Okay.
That's the message.
So it's really important that your agency or the person managing your SMS campaign is following the rules as well.
Yes.
Because at the end of the day, the consumer is going to really sue the one with the biggest pockets, which will be the brand. Okay, so why in this case, though, did the consumer, they sued Alarm.com, which is the brand. Why did that not work?
Yes, so this is, even though we gave the tip or the advice that just having a software provider or a third party that sends the messages for you doesn't release you from liability, it's also important for companies to know that that's not 100% in all cases. Not because a third party is selling your product, that means you're liable. I mean, there's a certain degree to establish that there was actually agency there. There has to be control, they have to be acting on behalf of. So there's legal principles that need to be met. So not every time someone sells your product, you're gonna be liable.
So in this case, Fisher versus Alarm, the people that were making the calls weren't really making the calls on behalf of Alarm.com. They were trying to essentially kind of sell Alarm.com's program, but weren't getting paid by Alarm.com to make the calls. I bet were getting paid on the back end if they sold an alarm system or something. So it was kind of a hands-off, like, hey, anybody in the world can sell Alarm.com products, and hopefully please do it legally, But at the end of the day, if you do it illegally, if we're not guiding you and telling you exactly how to do it and send these text messages or calls when, then the brand is really, it's not my problem.
Correct. And as an example, we have this case when the judge saw it, like he went to the facts. And what were the facts? Fisher, the plaintiff, said, I received all these calls, like several calls, and I'm suing Alarm.com. Why? Because he could only identify 2 calls. In one call, I asked the person I was talking to who was calling, and he referred me to the Alarm.com website. And in a second call, he was offering me Alarm.com products together with other products.
Okay.
The judge said, Fisher, those are not enough facts to have a reasonable inference that Alarm.com is controlling these people to call you.
Okay.
He is not the principal, and these callers are not the agents of Alarm.com. You cannot come here and sue Alarm.com for 20, 30 calls when your only connection between the unsolicited calls and Alarm.com is that one referred you to their website and another one offered you their product. There has to be a little more, like the standard is a little higher to prove that, to get to that inference and the TCPA litigation be able to proceed.
So if Alarm.com would have, employed these people or, contacted this agency and said, hey, we want you to call these 5,000 phone numbers. Here's the script. Here's a check, for your work calling them. If they're in the Alarm.com building, those are the things where then those people are, everybody's responsible.
Yeah, those are the specific facts that a court would review and say, like, yes, Alarm.com should be liable in this case. So the 2 messages I would get from this case for the viewers is, 1, having a third party sending messages for you does not release you of liability. You have to be there, review that they're complying with the TCPA, be sure that the rules are followed, right? But second, if you get sued, then also you have to get sued. You have to identify for what messages you got sued, because there's a possibility that there was just someone completely unrelated to you, that they just offer your product, and then you're going to have a good defense, right?
So doing some due diligence, if you're like Alarm.com, I bet they have many agencies and the affiliates. Luckily they did the research and they found out, wow, this person was getting calls from, I would say, an affiliate or somebody rather than like a marketing agency we hired. Mm-hmm. That's a great strategy to back themselves out of the lawsuit.
Yeah, and this was, even before that, this was a quick and inexpensive win for Alarm.com. Why? Because to prove their point, they only referred to the arguments that the plaintiff himself was making. Mm-hmm. They tell the court, look, he has not even linked me enough to consider that I'm liable, because he only has 2 of the several calls that he received said something about Alarm.com, but he hasn't. There's no one can reasonably infer that I was controlling the people calling him. The standard to be sued is a little higher, and in this case, Alarm.com was able to have a quick defense. They got the lawsuit dismissed. And
so dismissed means it essentially just goes away.
Yes.
Okay, and the consumer, they don't get anything.
They don't get anything.
And it doesn't go forward with the lawsuit.
Correct.
Okay. So that's a win.
Yeah, that's a win for Alarm.com without going through the whole process. And just because they were able to say, well, those third parties or those call centers that were making the calls, they're not related to me. Like, how could you prove that they were related to me? I know that my agents. So any company, a good practice should be, you should know exactly what third parties you are controlling, who are you telling them to call, what numbers are they calling. So when you get sued by somebody else, you have a good defense of saying, well, I don't see the link there for me to be liable.
It also seems too, when you do get the threat of a lawsuit or a lawsuit, it is always a good idea to engage TCPA counsel, because a lot of this stuff, the videos are great because I think they give an overview, but it's not enough to defend yourself or to settle a lawsuit without talking to a TCPA attorney, because there's just so many little gray areas. And also, if you don't, hire somebody to do the research, and this was a great win for them. If they would have thought that they were liable, they might have paid out millions of dollars for this, where just a little bit of research and knowing the TCPA saved them a ton of legal work and a ton of most likely money.
Correct.
Yep. Okay. Well, that's always a good thing. Always employ a TCPA attorney. And there is a difference between just like a regular attorney, like a business attorney, and TCPA attorney. you guys only focus on TCPA.
Correct.
Like live and breathe. You don't do divorces. You don't do wills.
No, just TCPA compliance, TCPA training, TCPA litigation.
So this is your life.
Yes.
Okay. So and this is the kind of stuff where these weird gray areas, you guys live and breathe this, where a regular attorney might just kind of know the basics almost.
Correct.
Okay. That's why you also go to a regular or just an SMS provider, because they're experts in SMS. You guys are experts in the TCPA. You get the best out of both worlds. So again, that is a TCPA case review. This one was from Fisher, which is the consumer, versus Alarm.com. And in this TCPA case review, Alarm.com was able to dismiss the lawsuit or get the lawsuit dismissed. Again, I'm Derek Johnson with Tatango.com, and this is TCPA attorney Ernesto Mendieta. That's a hard name to say sometimes. And we are reviewing TCPA cases here on the interwebs. And this was, again, a TCPA case review for Fisher versus Alarm.com.